Welcome back, everybody. Welcome back. I'm VR's Alan, Nathan, the militant moderate. Once again, this is the Oasis. For those who have an aversion to the left-right, black-white, two-dimensional approach, the recusal wars, Supreme Court Justice Thomas and Kagan face pressure to withdraw themselves from ruling on Obama's health care law. Also, there's still time to do what the super committee could not, reduce $1.2 trillion in debt with less pain than the triggers currently pose. But how? And from whom is the flip-floppery worse? Newt Gingrich, Mitt Romney, or Barack Obama? We have assisted me in the opining department, a couple of my regulars for this part of the day and this part of the week. Amy Ridenauer, president of the National Center for Public Policy Research and author of the highly acclaimed book entitled Shattered Lives. This analyzes the 100 worst examples of government-managed care casualties. You want a free copy? Go to the website, www.visitnationalcenter.org. Again, visitnationalcenter.org. Get a free copy of this very popular publication. Amy Ridenauer, good to have you back.
Glad to be with you, Alan.
On board as well, Robert Weiner, Democratic strategist, columnist, former communications director for Clinton drug czar General Barry McCaffrey, and former chief of staff for the House Committee on Aging. He's also former press secretary for both Congressman Rangel and Conyers out of New York and Michigan, respectively. Bob, good to have you back.
It's a pleasure, Alan, and I love how the right wing is trying to equate Thomas's taking lobby money and not disclosing it by himself and his wife versus Kagan, who is doing her job as Solicitor General. How they want to equate that is beyond belief.
Amy, to you, my understanding is that, well, basically he's saying that he's wondering how it is that Thomas can stay on the court after taking money from lobbyists. I guess he means it's ostensibly through his wife because he didn't take it directly,
and not disclosing it, which is required.
But that the Republicans would make such a big deal over Kagan, who, by the way, Bob, is in equal violation of that particular tenet because she did advocate for the very thing she would now be ruling. But Amy Ridenauer, to you first.
Okay, basically,
we're now talking about. By the way, we're talking about the health care bill. We're talking about the Obamacare under scrutiny come next March. Go ahead, Amy Ridenauer.
Next March, U.S. Supreme Court hearing of the case on whether the individual mandate is constitutional. The case that Bob just brought up of Justice Thomas has to do with his filing of how much money he and his wife got. The financial disclosure
his
form
non-filing.
all justices do. No. Let me finish, Bob. The filing of the form, which left off some of his wife's income. She worked for a nonprofit group with opinions on public policy issues, including the health care law. But everyone knew she worked there, so that was nevertheless fully disclosed. The issue at law is this. Are either of these justices, under current law, required or at least morally compelled to recuse themselves? I will argue that Kagan must and Thomas doesn't, and here's why, and I'll be Kagan.
Well, Bob, just have a listen. Amy, let me interrupt for a moment. Folks, what Amy, I think, is about to, I don't want to tell stories out of school. I'm just guessing. I haven't spoken with her about this beforehand. But she's about to explain the disparity that exists between 1 degree of separation and 0 degrees of separation. And
I can't wait to hear this.
We have a degree of separation where Thomas is concerned, but with Kagan, there is none because she was directly engaged herself, whereas with Thomas, it is with this 1 degree of separation, that being his. But Amy Ridenauer, go ahead.
It's not true because Thomas checked none.
Hey, I interrupted Amy, but I'm the host. Amy, go ahead.
Say I'm not right before you hear what I think.
Okay.
Kagan participated in the defense of the case that is appearing in the court decision. So she is involved as an attorney. And President Obama, when he nominated her for the court, knew this and took it into account and appointed her anyway. So, too, did all the senators who voted to put her on the court to be an issue. So Kagan, by taking the job and Obama by giving it to her, knew that she was disqualified. Now, how do we know she did this? Because 2 lawsuits forced the administration to let out emails that they should have put out without lawsuits in which she participates in the defense of the White House in this case. Now, Thomas, on the other hand, his wife holds opinions. I dare say every spouse of every justice holds opinions. They just don't necessarily share them. But Virginia Thomas doesn't make any more money. Indeed, arguably, she would make more money if this case loses from her perspective next year, for reasons I can explain but won't now. But Thomas does not benefit financially or in any other way based on this case and his wife's connections.
I wish it were true. All right, I get the response.
Bob Weiner,
right,
go ahead.
Alan? I wish it were true because I really want the Supreme Court to succeed. But Justice Thomas's wife emailed congressional chiefs of staff that she is, quote, an ambassador to the Tea Party movement, which opposes the health care law, and did not disclose his wife's earnings from conservative groups. Instead, checked the word none in the court's forms. And let me finish, Amy. I did not interrupt you. Okay. The Code of Conduct for U.S. judges, which unfortunately Supreme Court exempted themselves, the Code of Conduct for the U.S. judges says they should not personally participate in public fundraising activities. But in 2009, he was featured at the Heritage Foundation's fundraiser, which, of course, the Heritage Foundation vigorously opposes the health care law. Now, on the other hand, Justice Kagan was the Solicitor General of the United States. That it means that she was doing her job representing the administration in advocating for various things, and I'll be darned if somebody should be penalized for that.
Bob, that's so
Bob, everybody stop now. Here's the reality. Bob, you've taken, and everyone, by now my audience is pretty familiar with my theory on movable standards, wherein people rename a thing as being something other than what it is in order to gain the ground the arguments otherwise could not. I want my audience to bear witness as to whether or not either of you are guilty of that particular indulgence. I'm going to read here from the Washington Post. It said federal laws on the issue of recusal, whether or not they should recuse themselves. Federal law requires judges, including those of the Supreme Court, to disqualify themselves when their impartiality might be reasonably questioned. That's in quotation marks. When their, quote, impartiality might be reasonably questioned, unquote, as well as for specific reasons such as a financial interest or the involvement of a family member in the litigation. Okay. In addition, it calls for recusal when the judge has served in the government and, Bob, to you, quote, participated as counsel, advisor, or material witness concerning the proceeding or expressed an opinion concerning the merits of the particular case or controversy, unquote. And I want people to hear that again. In addition, it calls for recusal when the judge has served in the government and, quote, participated as counsel, advisor, or material witness concerning the proceeding or expressed an opinion concerning the merits of the particular case or controversy, unquote. There still might be ground on which to predicate some kind of argument against Thomas, but there's no doubt that Kagan denotatively or connotatively fulfills that definition. What am I missing, Bob?
You're missing that Thomas checked the word none in the court's form.
No, about Kagan. I'm happy to talk about Thomas, but you can't wiggle out of Kagan. You can't wiggle out of Kagan. Can't do it. You are incapable of wiggling out of Kagan. Only by altering the standards. Only by altering standards, because you're not able to meet the ones already in place, could you possibly be perceived by anybody as passing muster as it relates to this. More with both Bob and Amy Ridenhour upon a return. You are with Battle Line, Main Street Radio Network. I'm Alan Nathan.
We ought to have time enough for the two people who want to be our leader to talk in depth. Probably one of them would be unhelpful. I've already said that if he wants to use a teleprompter, that would be fine. If you had to defend Obamacare, wouldn't you want a teleprompter?
Welcome back, everybody. Welcome back. I'm ever yours, Alan Nathan, the militant moderate. Once again, this is the Oasis. For those who have an aversion to the left, right, black, white, two-dimensional approach, and you were listening to the musings of Newt Gingrich. Quick hat tip and nod and thank you to the folks at Real Clear Politics for capturing that video. But he essentially is saying that anybody who is honest about it knows that no person except Christ has ever been perfect. So I don't claim to be the perfect candidate. I just claim to be a lot more conservative than Mitt Romney and a lot more electable than anybody else. And this is what he told WSC-AM. This is a radio station in Charleston, South Carolina. We have Sister Me in the Opining, my regulars for this part of the day and this part of the week. First, Amy Ridenhour, president of the National Center for Public Policy Research. Amy, welcome back.
Thank you.
And on board as well, Bob Weiner, Democratic strategist and columnist. Good to have you as well, sir.
Thanks, Alan. You saw the Wall Street Journal editorial? The Wall Street Journal, your guys that said Gingrich's gaffe was telling the truth about deportation.
Yeah, that's responding to a question never posed, opposing an argument never asserted. I don't know why I would do that. Deportation. Well, Amy Ridenour, to you, he's talking about the illegal immigrants. The reality is, it strikes me as if we're preoccupying ourselves with a secondary or tertiary consideration. Fine, these are important matters, but if the original measure is the one that we maintain as the highest priority, that is, of course, sealing the border and enforcing our immigrant laws, well, then all we're doing in that instance is adhering to the Constitution. Any other changes people want to make, they should do so by way of legislation or constitutional amendment, not telling me that in the name of a noble cause they have a right to trample on far nobler principles. What am I missing, Amy Ridenour?
I don't think you're missing anything. I completely agree. The way you handle the immigration issue is in the Congress with the debate. Yes, you involve the public, but you have a comprehensive debate, and then you actually execute what you decide. And that's the biggest problem we have on immigration. The public is in disagreement with the policy that the government de facto has. We've really got to have the policy that we claim to have and actually follow through.
Bob, in other words, if we have laws on the book as a matter of applying things with some universal approach of neutrality or universal standard of neutrality, instead of doing so, we're pulling our punches, allowing some treatment to be afforded to certain folks. And besides, you're on record as already agreeing with me on immigration. I've always said that the Solomonic approach would be to say, hey, upon sealing up the border, let's have pathways to citizenship. But you've got to acknowledge America's entitlement to have their Constitution fulfilled and not have pending legislation be the thing on which such compliance is contingent. You're already on record as agreeing with me, Bob. I've said before the two biggest problems here are corporate righties wanting cheap labor and socialist lefties wanting cheap votes, and that while a slight majority is okay with pathways to citizenship, consistently 70% of the country is always saying, let's seal up the borders before we have pathways to citizenship. You've not changed your position on that, have you, Bob Weiner?
No, Alan, and I agree with you.
Glad we
I
had
agree
this
with
chat.
Schlafly. This conservative Democrat here speaking to you now will tell you that absolutely you must seal the borders first. What I'm quarreling with is the hypocrisy of the Republican right that doesn't realize that at the same time that you seal the borders, you're not going to deport 11 million people
Nobody does that.
Over to Mexico.
Nobody says that. Nobody says that. It's a complete,
nobody says
and
that.
that's a categorical, masturbated falsity. Because the truth is, guess how many people, Bob and Amy, you need to kick out of this country before you can seal up the border? Guess how many are required to kick out of this country before we can move forward with fulfilling Article 4, Section 4 of the Constitution, as well as a whole host of different federal laws? Amy and Bob, guess how many illegal immigrants are required to be kicked out of this country before we can start sealing up the border? None! Absolutely none! Zero.
Valid,
I'm looking at the clock, and I want to go back. I want to go back to SCOTUS. I want to go back to the
agreement on this one.
All right, now I want to go back to SCOTUS as it relates to both Clarence Thomas and Justice Kagan. To you, Amy Ridenour, was I oversimplifying it, or am I showing that there's an epitomizing of apple-orange comparison? Skipping a box on a tax form, in my estimation, does not make Clarence Thomas anywhere near as conflicted as is the case with Ms. Kagan. Justice Kagan, I think, is far more entrenched with a conflict of interest than could ever be associated with Clarence Thomas. For one reason, it's Clarence Thomas's wife's interests that would be getting held against him if we say he must recuse himself. Whereas with Ms. Kagan, Justice Kagan, she is in the pivotal center of the very controversy. She, if she hadn't been nominated to the Supreme Court, continuing in her previous position, would be in front of the Supreme Court defending the Affordable Care Act, and therein lies the huge disparity between the two as it relates to the measure of conflict of interest. What am I missing, Amy Ridenour?
Missing nothing. For Kagan to be hearing this case is like a person being both the batter and the umpire. You can't do it and be fair. Now, Thomas's case is simply different. Even if he failed to fill out a financial form correctly, it has nothing to do with recusal. If it did have something to do with recusal, then he would have to recuse himself from every single case a mainstream conservative organization had an opinion about. And let's add by saying, and I'll make this one sentence, Thomas and his wife have no financial or direct interest in the resolution of the case beyond the same interest as every other American citizen.
Well, you're just not right.
Robert Weiner, husband of Pat. Robert Weiner, husband of Pat. Are you there? Can you hear me? My question to you is this, Robert Weiner, husband of Pat. Would you not acknowledge that the level of advocacy between Kagan and Thomas is vastly different, and that she did once advocate where he did not, and therein lies a chief disparity?
Absolutely not, because in 2009 he was featured at a Heritage Foundation fundraiser, and which is specifically prohibited by Supreme Court ethics, and by checking none of the organizations, the money that came in from his wife on health care, it is an absolute lie. And his wife said in her emails, for influence, use me, and I'll get you influence.
Okay, I'll tell you what. So I acknowledge in advance that I have absolutely no control over somebody else's power of delusion. So if you don't understand that Clarence Thomas would have to recuse himself from everything universally if we allow this to be the new measure, I can't help it.
And
if
so
that's what you think, that's what you're stuck in thinking.
She was in the administration which advocated for all kinds of positions. So it's a nonsense parallel.
No. In this instance, we're talking about a very specific piece of legislation to which she was specifically attached in advocacy form. It is the epitomizing of apple-orange comparison, Bob Weiner, for you to compare a guy who skipped a box to somebody else who proactively engaged in advocacy. Again, there is such a disparity between the two. I don't see how you can intellectually get around this.
Clarence Thomas, unlike any other justice, speak to anybody
Bob Weiner, are you going to deny right now? Are you going to deny that Kagan? Are you going to deny, Bob Weiner? Are you going to deny right now that Kagan sitting in judgment of this is tantamount to her sitting in judgment of that which she was directly going to advocate from her former position?
And Thomas is a blank check for the right.
Bob, everybody shut up for a moment. Bob Weiner, to you, I'm asking a direct question. Are you going to deny that but for her appointment to the Supreme Court, Ms. Kagan would be currently engaged in defending the very legislation that is currently being judged by that court?
And she was the Solicitor General of the United States doing her job, and you don't penalize somebody for being a public servant.
Stop saying that.
The two following things are not mutually exclusive. We don't have to be penalizing somebody in order to still hold them in compliance. Now, if holding somebody in compliance happens to compel them to give up or do without something they prefer, so be it. But the primary measure is always conflict of interest. So if conflict of interest can be demonstrated, Bob, I have to ask, are you at all familiar with the Queen's English? If doing her job, as related to this particular legislation, if doing her job then puts her in a conflict of interest now, you're stuck in a cul-de-sac out of which you cannot extricate yourself. But instead of continuously embarrassing you, because I don't want you to be seen as silly as you sound, I'm going to move on right now. To you, Amy Ridenour, we have some hypocrisy in the place of Newt Gingrich, do we not? He wants to attack Mitt Romney as a flip-flopper, but he himself has a long list of flip-floppery, does he not, Amy Ridenour?
Well, to be honest with you, all of these candidates do, or at least all of the lead ones in almost every single election. I'm not going to argue with you, but neither I'm going to say that it makes any of these guys, including Obama, Romney, Gingrich, the list goes on, they all change their minds.
And Gingrich is more consistent than most, by the way.
More so than Obama. Well, thanks for sharing. We appreciate that, Bob.
I said most. Obama also.
Well, Obama, of course, he was for the D.C. gun ban before he agreed with the Supreme Court that rejected it. He was for Chicago's gun ban before, the Supreme Court rejected it. He was against the individual mandate before he supported it, which is now before the Supreme Court. Funny how time changes circumstances, isn't it? Bob Weiner, Amy Ridenour, always a blast. Folks, you are with Battle Line, Main Street Radio Network. I'm Alan Nathan. The news wrap-up right next.